Stormsure Ltd and the Secretary of State for International Trade and Minister for Women and Equalities.
Yes, Mr. Mills.
Yes. Good morning, my lord. My lords, my lady. I appear via the Equality and Human Rights Commission for the appellant, the claimant, Mr. Purchase QC for the Secretary of State. Once an intervener, now a fully fledged party, I think is the position. And Mr. McHugh appears for the respondent. My lady, my lords, an employee dismissed for reasons as varied as trade union membership, making a protected disclosure, trusteeship of an occupational pension scheme, or accompanied at a meeting to discuss a request to enter into study or training, has a powerful tool at his or her disposal. They can hold the ring and preserve the status quo by way of an interim relief application. If they satisfy the high thresholds of an interim relief application, they can benefit from either reinstatement or re-engagement or a continuation of the contract. But what are the following dismissed individuals? The employee who notifies her employer of her pregnancy, the employee who reveals their sexual orientation in the workplace or a diagnosis of a disability, the black, Muslim or female employee faced with the ignominy of a new bigoted manager, the employee who rejects her boss's unwanted sexual advances, or the employee who speaks out about discrimination endured in the workplace. Those individuals must join the back of the queue and await protracted proceedings. They may have to wait months, or in some cases, involving jurisdictional issues, years for a finding of liability in their favour, and longer still for remedy. By the time that remedy is awarded, their jobs have been filled. They may have been in the open labour market throughout that period, lumbered with the stigma of ongoing tribunal proceedings and dismissal for a discriminatory reason. Those individuals, by reason of their protected characteristics, are statistically sometimes more likely to experience longer periods of unemployment, and yet they are consigned to post hoc remedies, which are often not paid. The Commission and the appellant say that disparity of treatment is untenable. On proper analysis, it's not been considered by Parliament, still less adequately answered. It's incompatible with fundamental convention rights, and in particular Article 14. And the claimant in this appeal, with the support of the Commission, urges this court to resolve that disparity. On proper reading of Parliament's intention, evinced through Section 3 of the Human Rights Act, we say not only that the court can, but that it should resolve that discrimination. I'll address you briefly on the procedural history before then turning to the EAT's reasons and the framework of interim relief before advancing 7 propositions. Firstly, in being deprived of interim relief, those dismissed on discriminatory grounds are barred access to a thing of substantial value. Secondly, the absence of interim relief falls within the material scope of a substantive convention right. The EAT concluded Article 6 and reached no conclusions as to Article 8 or A1P1, but we say all 3 we're within the ambit of all 3. Thirdly, the affected individuals, of which the claimant is one, have a valid Article 14 status. On proper analysis, the status is the protected characteristic which forms the basis of the claim, because the dismissal is infected by that characteristic, here sex. Alternatively, the status falls within the category of some other status, namely those pursuing claims of dismissal on discriminatory grounds. Fourthly, the comparative test envisaged by Article 14 is broad. The claimant may validly draw comparison with those who benefit from interim relief, and in particular, whistleblowers who were dismissed. They are in an analogous situation. Fifthly, that discrimination is unjustified. Given the nature of the rights and status in issue, a heightened standard of justification is necessary. At a minimum, an ordinary proportionality test is to be applied. The onus rests with the Secretary of State to make out a justification defence. On improper analysis, she does not begin to do so. 6. The statutory requirement on the court to achieve a convention-compliant reading, insofar as possible to do so, is sufficiently wide to remedy the Article 14 discrimination in the present case. The drafting is not of the essence, although, as Mr. Justice Cavanagh recognised, the wording suggested by the claimant before the EAT would remedy the issue subject to the limits of Section 3. And then finally, as a matter of last resort, a declaration of incompatibility should be made. The government does not dispute that if there is unjustified discrimination, but you're with the Secretary of State on Section 3, that a declaration of incompatibility should be made. Turning to background first, the facts are to be taken at their reasonable highest, and given, as Mr. Justice Cavanagh recognised, this is essentially, as he put it, an issue of pure law of public importance. I don't propose to spend too much time upon them. Paragraph 18 of the EAT's judgment, page 210 of the core bundle,
Yes.
essentially tells you all you need.
Yes.
In a nutshell, claimant alleges that she was subject to unwanted harassment by a colleague. It turns out, as I set out at paragraph 7 of the skeleton argument, page 17 of the core bundle, that individual had previously been convicted for stalking-related offences. To the best knowledge of the claimant, he remains employed by the respondent. The claimant raised concerns as to his conduct. She alleges they were not adequately dealt with. She requested home working to remain absent from him in order to safeguard her own well-being. Her employer imposed intrusive measures of monitoring her work and then unilaterally reduced her hours to 60%. She alleges that constitutes an express dismissal following Hogg-and-Dover College, alternatively a constructive dismissal, and it's clear on the framing of at least the ERA that a constructive dismissal may nevertheless found a claim for or an application for interim relief. The procedural background is dealt with without controversy, paragraphs 18 to 26 of Mr. Justice Cavanagh's judgment. If you want various page references as to the procedural history, the interim relief application is found at page 328 of the core bundle. The Tribunal's initial response, 30th of July 2020, page 290, essentially will hear you on one aspect of the application but not the other. The claimant asked for there to be full argument on the Equality Act interim relief issue. That was refused, page 291. An appeal presented soon after that refusal to the EAT, pages 284 to 289. Preliminary hearing before Mr. Justice Cavanagh on the 17th of November, at which point the Secretary of State was invited to intervene before the EAT, but did not do so. The circumstances as to the non-participation are unlikely to assist the court in any event. They were not there. Substantive appeal, 15th of December, judgment, 21st of December. One important point to make there, at that stage the claimant was advancing EU law grounds as well.
Yes.
And there was a rush to the finish line because of the EU Withdrawal Act. And despite the challenges that the claimant makes as to aspects of the EAT's judgment, she wishes to state on record this. For the EAT to produce a judgment, any judgment, within a 6-day window was impressive. For the EAT to produce a judgment of this calibre in that window was little short of extraordinary. And it respectfully does a disservice to that judgment to submit, as Mr. Purchase on behalf of the Secretary of State does, that it's essentially proceeded by way of concessions. It did not. On the Article 14 issue, if I take you to paragraph 2 of the Secretary of State submissions, that's page 49. in a judgment based to a large extent on concessions and lack of submissions on justification. Now, we say on the first questions of Article 14, substantive right, within the ambit of substantive right, Article 14 status, comparison, it is simply not fair to categorise this judgment as proceeding by way of concessions only, in the sense that on each of those questions, the EAT considered independently whether those concessions were rightly made and reached its own conclusions as to substantive right, status, comparison. I don't propose to spend too long on the EU point,
No.
but in terms of the structure of the judgment, the EAT addressed the scheme of interim relief at paragraphs 27 to 40, much of which we accept. And then at paragraphs 52 onwards, albeit in the context of whether the absence of interim relief breached the principle of effectiveness, there were nonetheless important points made as to the benefits of interim relief. This is at page 226 of the core bundle. And the four benefits that the claimant identified: restoration of employment, which is the primary question, albeit the continuation of contract orders are more frequent; swift redress; the avoidance of cost; and speedy access to an effective financial remedy. The EAT concluded that 2 and 4 there perhaps amounted to the same thing. But as the EAT also accepted, just at 53C, page 227, the wait can last months or in complex cases more than a year. In the meantime, as the claimant will have lost his or her job and may not have found another one, the claimant may well be facing financial hardship. Interim relief provides a very welcome financial cushion. And then 54, receipt of a financial remedy which may be substantial, which is not repayable, and then interim relief without succeeding in establishing the claim full merits. Of course, those points also apply in relation to the existing protection for interim relief. And then it's 64 on a similar theme, page 231.
Can you do it by paragraphs? Because I'm using a different copy of...
That's fine. So it's paragraph 64.
Yes.
I accept, therefore, that there are frequently substantial delays before a deserving claimant in a discrimination, victimisation, or claim will receive an award of compensation. EAT concluded that there was nonetheless not a breach of the principle of effectiveness on application of EU authority, marshal, etc. Effectiveness, it was concluded that the comparison between the legislative provisions of Section 39 of the Equality Act and 103A were comparable, but there were various other features to consider, not least the proviso, which applies in relation to the domestic claim of unfair dismissal, and so therefore it couldn't be said that there was a breach of the principle of effectiveness. When it comes to the HRA grounds, the EAT concluded that in the material scope of Article 6, because paragraph 181 or 180, the case comes within the ambit of Article 6 because it relates to access to judicial remedies for the enforcement of civil rights, reference to Laing, in which the cost regime for discrimination claims in the civil courts was held to be within the ambit of Article 6. Not necessarily to show a breach of one of the other articles, and not necessarily to address the more complex questions, as in the matter in question also comes within the ambit of Article 8 and or A1P1. Then paragraph 182 on status, citation of all the applicable authorities, before concluding at 184, that the relevant status is that of an individual who wishes to bring a claim of discrimination or victimisation arising from dismissal rather than the core status of sex or gender. To the extent that that matters, that's not accepted by the claimant, but we agree with and respectfully adopt the conclusion of Mr. Justice Cavanagh at paragraph 185, that the standard of scrutiny would essentially be the same, whichever of those two statuses one adopts, because there is a close connection with a core status of sex, and fundamental rights are in issue. Then, when it comes to analogous situation, citation of Stott and Carson, the real question being, as this court and the House of Lords, or now Supreme Court, has held, the real question is whether the difference between the two categories of claim which justify the availability of interim relief for one but not the other, and the EAT had little issue in saying that there was a valid comparison to be drawn between the dismissed victim of discrimination and the dismissed whistleblower. Absent anything in relation to justification from the Secretary of State or the government, the discrimination was found not to be justified. And then we come to purpose of construction, which I will, of course, deal with in rather fuller detail. Of course, what the EAT could not do is grant a declaration of incompatibility. And we say that on those fundamental building blocks, material scope of a substantive convention right, valid status, analogous situation, those conclusions are, as a flaw, are not open to the challenges advanced by the Secretary of State. It is notable that despite having received the written submissions of the Secretary of State, the respondent has confirmed that it does not seek to withdraw from the concessions made before the EAT and does not adopt the Secretary of State's submissions in relation to those issues. And so we say, subject to any new material that the Secretary of State brings to the table on justification, the real question is one of disposal.
Well, that can't be right, Mr. Wilson. This is a hugely important case. We can't possibly say, well, these points weren't taken in the EAT, therefore that's the end of the case.
That's not what I argue.
No.
What I argue is that on proper analysis, those points are not well founded.
Right. Okay.
I would not suggest. There's some dispute as a matter of procedure, and you'll notice that there was a separate notice of appeal in relation to the Secretary of State's position. Whether it's treated as a separate appeal, whether it's consolidated, clearly these issues are important, and a determination from this court in full, rather than getting through on a technicality, would be entirely wrong. That's not what I seek to argue. What I do seek to argue is, on analysis of those points, the EAT was right to conclude as it did. My lady, my lords, what's interim relief all about? What's the framework? And what are its benefits? The scheme, as set out by Mr. Justice Cavanagh at paragraphs 27 to 40, is largely undisputed. It first arrived into the employment framework via the Employment Protection Act of 1975, and the claimant accepts that at that stage the purpose was clear. It was to deal with the particular mischief of industrial relations and trade union activity or membership. The picture has changed, and it's changed principally, we say, via the extension of that remedy to whistleblowing complaints. The scheme was then replicated into the Employment Rights Act And you have the relevant provisions. Volume 1 of the authorities bundle if you're in physical format. Tab 4. Sections 1 to 8 onwards. Page 30 of the authorities bundle. The application must be made pursuant to section 1282 before the end of the period of 7 days immediately following the effective date of termination.
When was the effective date of termination in this case?
Let me check. 15th of July. 15th of July last year.
Possibly the application to the tribunal was a day or so out of time. I'm not suggesting we should say if it was, that's the end of the case, thank you and goodbye. But it does look to me as though it was.
Well, it was certainly presented. I think it was presented
23rd.
on the last day. I think it was presented on the last day. Yeah. And then, of course, the tribunal must must determine the claim or the application as soon as practicable after receiving the application. It does so on a swift and summary basis. The ordinary rule is that there is no hearing of evidence. It's an exceptional case where evidence is heard. And the test for the granting of interim relief is a high one. Principal question, or primary question, is whether there should be reinstatement or re-engagement, pursuant to section 129, on terms not less favourable than those that would have been applicable had they not been dismissed, as regards seniority, pension rights and similar rights. And then section 130, if reinstatement or re-engagement is not practicable, an order for the continuation of contract for the purposes of pay or any other benefit derived from the employment, seniority, pension rights and other similar matters. So the contract continues, claimant continues to receive such sums that they would have received or would have been entitled or expected to receive were it not for the dismissal. Those sums that an employee could reasonably have been expected to earn during that period, until determination of the settlement or settlement of the complaint. There are clear and obvious benefits to that interlocutory measure being available in the employment tribunal. Firstly, the Supreme Court has held in a suite of cases, P, Michalak, Unison, that the employment tribunal is the specialist forum for workplace disputes, rather than having to, say, get an interim injunction or anything of that nature in the civil courts.
Couldn't possibly get an interim injunction in the civil court. The only circumstances in which injunctions to maintain, let alone restore, contracts of employment are ever granted are one where there is a procedure which hasn't been followed and the contract can be kept alive.
NHS cases,
until-
for example.
Yeah, no. Chabra and that sort of
Matu, etc.
Or two, the extraordinary facts of Hill and Parsons, one of Lord Denning's cases, where the employer didn't want to sack the employee and was put under pressure. So trust and confidence are maintained. With those two exceptions, I don't think injunctions are ever granted in the civil courts.
Well, in which case I don't need to be in the shallow end of saying that the tribunal is a preferable forum for it. I mean, because you're right.
It's the only forum.
It's the only forum, and of course, it's generally speaking non-cost bearing, no undertakings and damages, etc. It is a remedy of very real value. And
have you finished with sections 128 and 129?
I have, unless there's anything.
Well, I do have some questions. Let's look at practicalities. How long would such a hearing take?
The general scheme of interim relief applications is a day for hearings of no less complexity.
Yeah. Okay. And section 1285 says the tribunal can't postpone the hearing except special reasons. So there's no question of a prior case management hearing or anything like that. That is the hearing. The employment judge will have a witness statement from the complainant, possibly some in support. The employer has to be given 7 days' notice, but no more. The employer may have got its act together and produce some witness statements. What's the employment judge supposed to do? Say, I believe X rather than Y?
Well, on the case management issue, there are cases, and applications, I've been involved with some of them, but also they're cited in the authorities, where there is case management before an interim relief hearing. In Tarberg, in the EAT, one of the issues was raised was that there shouldn't have been a case management hearing before the interim relief application. It's Justice Chowdhury did not accept that, and so that in certain cases that there may well be case management.
Okay. Well, what is to happen at the hearing?
Well,
no oral evidence, no cross-examination.
Well, in a sense, my lord, you're one step ahead of me, because this is a remedy that will only be granted in exceptional circumstances.
Why? If you're right, this is going to be a feature of almost every unfair dismissal claim, I would have thought, where the complainant can say, for whatever reason, this dismissal is tainted by discrimination, sex, race, disability, anything else.
Well, my lord, if that were right, given the obvious benefits of pursuing an Equality Act claim more generally, uncapped damages, etc., then there would never be an ordinary unfair dismissal case.
So there would never.
Then there would never be an ordinary unfair dismissal case if people were motivated.
Well, I think you're right.
No, forgive me.
Yeah.
On the current scheme, let's leave aside the appeal for a moment. Well-established limitation of an ordinary unfair dismissal claim is that damages are capped. But not every dismissal is contorted into a discriminatory dismissal, despite the obvious advantages of uncapped damages. So, my lord, I'm afraid I don't agree that every dismissed employee will contort their dismissal into one of a discriminatory dismissal, because they don't at the moment, notwithstanding the obvious advantages in doing so.
No, but if the possibility were... start again. Mrs. Steer resigned after 4 months in post and claimed constructive dismissal.
But express dismissal was her primary case because of the reduction.
Express alternatively.
Yeah.
Constructive. If it was simply unfair dismissal, she'd be nowhere near the 2-year qualifying period. So that would rule her out. There's been no trial of the facts. If on the facts as put, she has, we don't know at this stage. But why would not any employee who resigns after falling out with the employer, who alleges repudiatory behaviour by the employer, who can say, I was harassed or I was discriminated against, why would she not go for interim relief? I mean, there's nothing very exceptional about the facts of this case. Why would you not go for interim relief?
Well,
it's a one-way bet. No costs risk, no undertaking in damages, no liability to repay. Tribunals are choked with work at the moment. So if an employment judge holds that you've got a pretty good chance of success, you've got maybe a year's full pay with no downside. Why do you say this would be exceptional? It'll be absolutely commonplace.
Well, there are 2 points. Firstly, on the facts as alleged, this is pretty exceptional in the sense that the claimant was exposed to sexual harassment by somebody who was convicted for stalking offences.
No, I understand that.
Raised complaints and said they were inadequately dealt with.
Yes.
And then subject to a unilateral reduction in work and pay.
Yes.
So we say on the facts as alleged, taking the facts at their reasonable highest, as one must for this appeal, there are some exceptional features. But the second point is this. Interim relief for whistleblowing claims has been on the books since 1998.
Mm-hmm.
The introduction of the public interest test, one could simply complain about one's own contract of employment, Parkinson's Sodexo. And yet, the tribunal has not been littered with interim relief applications for whistleblowing dismissals or constructive dismissals. And the reason for that, I'd say, is the tight control mechanisms over the application, of which we say there are 6. Firstly, the timescales. My lord's identified in this case already how tight they are. In circumstances where many individuals struggle to present their claims in 3 months, which is why there are so many applications for extensions of time, fewer are in a position to present an interim relief claim within 7 days. It just doesn't happen that often. The number of applications that are cited in the Secretary of State submissions and witness evidence suggests that there are 119 a year on average.
119 what?
Applications for interim relief a year. In the last 5 years, 119.
Do we know how many whistleblowing claims there are overall, not with interim relief?
Well, there's in terms of the statistics, because PEDA comes out at I think 3,000 or 4,000. But unfair dismissal and others are 10, 15,000. Now, what is unclear is whether the unfair dismissal includes unfair dismissal for protected disclosures, or whether PIDA, the jurisdictional classification, is only in relation to PIDA detriment complaints rather than unfair dismissal on grounds of PIDA. The jurisdictional codes are not altogether clear. What we don't know is how many of the 119 applications on average are whistleblowing per year. But
I would guess the majority.
one would have thought.
The trade union and health and safety and similar are, I think, statistically more infrequent.
Yes. Yes, I think that's right. The second control mechanism is the nature of those proceedings. Rule 95 of the Rules of Procedure Regulations makes clear that the tribunal will not hear evidence unless it directs otherwise. This is what was described in the EAT case of Chaco, which you should have at tab 32 of the authorities bundle if you're on page numbers at 685. Paragraph 23. Recorder Luber, QC, said this: in my judgment, the correct starting point of this appeal is to fully appreciate the task which faces an employment judge on an application for interim relief. The application falls to be considered on a summary basis. The employment judge must do the best he can with such material as the parties are able to develop by way of documents and argument in support of their respective cases. The employment judge is then required to make as good an assessment as he is promptly able of whether the claimant is likely to succeed in a claim for unfair dismissal based on one of the relevant grounds. Relevant statutory test is not whether the claimant is ultimately likely to succeed in his or her complaint to the employment tribunal, but whether it appears to the tribunal, in this case, that the employment judge, that it is likely. An expeditious summary assessment by the first instance employment judge as to how the matter looks to him on the material that he has. The statutory regime thus places emphasis on how the matter appears and swiftly convenes summary hearing at first instance, which must of necessity involve a far less detailed scrutiny of the respective cases of each of the parties, and their evidence will be ultimately undertaken at the full hearing of the claim. Swift and summary and expeditious. The third point is, what is the test on that swift and expeditious basis, and where is the burden? Burden rests throughout on the applicant, and the burden is a high one. It is not simply a balance of probabilities. It's what Mr. Justice Slynn, as he then was in Taplin and Shipham, called a higher degree of certainty than the ordinary civil standard.
He said a pretty good chance, didn't he, whatever that means?
Well, he said pretty good chance, but also said a higher degree of certainty than the ordinary civil standard. And there's been various attempts along the way to depart from that. In the case of Danpat, which you have at tab 28, should you need it, paragraph 20, there was an effort by then Mr. Laddie.
Sorry, which tab?
Tab 28. And it's paragraph 20. Meaning of likely. An effort to argue before then Mr. Justice Underhill that likely should mean no more than likely in the disability context of could well happen. That was rejected. Likely tended to show an increasingly less rigorous approach. On ordinary principles, we should be guided by Taplin, unless we're satisfied as it's plainly wrong. Very far from the case. We do in fact see good reasons of policy for setting the test comparatively high in the way this tribunal did in the case of applications for interim relief. If the relief is granted, the respondent is irretrievably prejudiced because he's obliged to treat the contract as continuing and pay the claimant until the conclusion of proceedings. That is not a consequence that should be imposed lightly. And we agree. Conversely, there's been efforts to say that something close to virtual certainty is the test. One waits for appeals on interim relief to reach this court, and like buses two come along at once. In the case of Al-Qasimi and Robinson a couple of weeks ago, there was an application for permission, as I understand it, to say that the test should be one approaching virtual certainty, having regard to the Article 1, Protocol 1 rights of a respondent to pay the claimant for the continuation of the contract. That application did not succeed, whilst there were other aspects of Robinson which were heard a fortnight ago. That was not one of them. Because what is understood is the test is higher certainty than civil standard, but not an absolute certainty. Like the Goldilocks three bowls of porridge, this one's just right. It pitches the competing interests perfectly. Tribunals well understand that something beyond the civil standard is required. And that's why successful interim relief applications are rare. It is not lost on the tribunal the consequences of making such an award. And that test applies to each and every element of an interim relief application. If I can take you to tab 54 of the authorities bundle, case of Tarberg. Tarberg concerned the question of, it was a whistleblowing interim relief application, as to how...
Which have you in?
54, my lord.
54. This is the case that's called Simply Smile, is that?
Simply Smile, and Tarberg is the...
Tarberg.
Right, Tarberg. They concerned the question, how should the tribunal grapple with a question of employment status? Because, of course, on the regime as it stands, one can only bring an interim relief application if one is an employee. And the approach taken by the EAT is that at every stage of the interim relief considerations, the test of pretty good chance, beyond merely balance of probabilities, is the appropriate one to adopt. If I take you to paragraph 30 onwards, 1391, you see the analysis. If I may, I'll ask this to go on the reading list for another stage, but for present purposes, paragraph 44 what was urged by the respondent is that there should first be a detailed consideration
That would be hopeless.
on its merits.
Then you spend 6 or 12 months deciding whether the tribunal had jurisdiction to make a section 128 order.
And then backdate the order, as suggested. And as Mr. Justice Chowdhury concluded at just above D, that would be small comfort for a person who's lost his job for having blown the whistle or for having raised trade union matters. It must be borne in mind that the Section 128 procedure envisages an expedited process whereby an interim relief application is heard as soon as reasonably practicable, and which can only be postponed if there are special circumstances justifying such a course. Does not seem to me to be a special circumstance for a respondent to challenge employee status so as to warrant the postponement of the interim relief application. Such challenges are commonplace in employment disputes. And then if we continue to 45F, There is no or little risk of the right to seek interim relief being abused by persons who are not even arguably employees or who clearly did resign voluntarily. The experienced tribunal hearing the interim relief application would undoubtedly quickly nip such abusive claims in the bud, on the basis that the applicant gets nowhere near the likely to succeed threshold in respect of those issues. Even cases where an applicant was able to establish a 51% chance of establishing employee status would not be eligible for interim relief. True it is that if an initial assessment that the claimant has a pretty good chance of establishing employee status is later disproved, he or she would not be required to repay any interim repayments that were ordered, and that might be prejudicial to the employer. However, it seems to me that is a risk that applies in respect of any interim relief application, and not just one where employee status might be disputed. Continues on 46. I do not foresee any particular difficulty in tribunals adjudicating on issues such as employee status, or whether there was actually a dismissal relief stage. As has been said many times before, the analysis at this stage would not involve a full assessment of the facts, but a summary assessment based on limited evidence, usually in the form of written statements and documents. An experienced employment tribunal is well placed to assess, on a summary basis, the prospects of success in a claim where employee status is disputed, and will be in a position to determine whether or not there's a likelihood of success on that preliminary issue.
Well, I'm sure that's right with respect, but I'm not sure that you can translate that into discrimination claims, which are very often, maybe not in this individual case, but very often much more complex, involve much more nuanced assessments. Some, though not this one, involve courses of conduct stretching over years, and which are going to lead to a tribunal case lasting for weeks. Very difficult for an employment judge to make a summary assessment of the prospects of success of such a case on the papers without hearing all evidence.
In which case the application will fail. And that's the point, my lord. Mr. Purchase, when he stands, will seek to argue that there's been a deliberative choice here as to the extension or otherwise of interim relief. On proper analysis, that's not so. On proper analysis, at no stage has Parliament considered whether interim relief should be extended to Equality Act dismissals. And the veto applies to any guise of discriminatory dismissal.
Sorry, the veto.
Well, there is no discriminatory dismissal where interim relief may be awarded. Take cases which are incredibly straightforward. Employee announces that they're going to be on maternity leave, dismissed. Regrettably, not atypical.
Yes.
The current regime allows for no room for any such application at all. We say, Mr. Justice Chowdhury was right, that the tribunal should be trusted. The burden rests on the claimant, on the applicant, and if on a swift and summary assessment of the papers, the application cannot be made out, then it will fail. This is not going to be a remedy for cases which rely upon inferences or mass disclosure or oral evidence. The application will simply fail. Which brings me on to the fourth, actually, before I get to the fourth point, on the high threshold. Can I take you back to the EAT's judgment, which is paragraph 55 of the judgment.
And simply smile.
Forgive me, in the EAT judgment in this case.
In this case.
When Mr. Justice Cavanagh said this, it's partly because the consequences of a grant of interim relief are so significant both for claimants and respondents that the evidential threshold for interim relief is so high. So high. We agree. And few claims and few applications will meet that threshold. All the Commission asks is for those that do they have the opportunity to make the application. And at the moment, they simply don't. The other reason is that the ET is having to form a judgment on the basis of limited evidence and without hearing oral evidence. The reality of it is, if faced with an application or we want to give evidence, that's a surefire sign that it's an application which is not going to succeed. Because once one's in that territory, clear that it's not likely on the papers, it doesn't meet the higher standard of certainty that Mr. Justice Slynn envisaged, and Dan Pat and Taplin, Terberg, etc. follow. And therefore the application would fail. The fourth control mechanism, we say, is that where an applicant has no real prospect of establishing that high test, a costs order could, and in certain cases, should be made. When considering whether there's a reasonable prospect or whether there's a reasonable pursuit of litigation, if a claim is axiomatically nuanced, etc., such that the tribunal can readily conclude that the application is unlikely to succeed, it has no sensible basis of determining whether it could, that's within the territory, or at least within the arguable territory, of course.
But are you saying that a complex case would fail because it's complex?
Yes.
Really? So that, but isn't the employment tribunal bound to grapple as best it can with every case and make a decision, however unsatisfactory it might be to be forced into that position? The person with the good nuanced case shouldn't suffer the discrimination of not getting the interim relief that would be granted to the person who has a weak but good-looking case at the interim stage, and nice and simple, they say, he said, get out your, whatever they, an obvious example of discrimination, which turns out at trial to be made up.
Well, I'll deal with the fabricated allegation situation in a moment, because it seems to me that there's an answer to that. Clearly, the task of the tribunal is to grapple expeditiously, summarily, as best it can, with any application that it receives. There will be some cases that are straightforward, there will be some cases that are more complex, but in each instance, that's what the tribunal will have to do. But where it's clear that as best as it can do that, this is just not an application which is right, this is not a case which is right for the application, then the application will be dismissed, and the tribunal has the full case management tools at its disposal.
Okay, that was number 4.
5. Section 131 of the ERA, the tribunal has the power to vary or revoke any order on application. And 6, and this deals with my Lord Justice Warby's hypothetical, reconsideration of a tribunal's own initiative, the powers of reconsideration that a tribunal enjoys. One of the issues raised in Robinson, this court, a little earlier this month, was whether the tribunal has a power to grant reconsideration of its own initiative in relation to an order that has been made, and made on a knowingly false basis. So, for example, someone makes an allegation up as to discrimination, forges a witness statement, fabricates documents, etc. There's no known instance of that on the decisions that have reached the tribunal, but we say that it is at least arguable that the tribunal could deal with that injustice by way of its powers of reconsideration, i.e., you presented a case which you knew to be false, or based upon forgery, or based upon fabrication. Had we known what you knew at the time of making the application, we wouldn't have made the order. We exercise the power of our own initiative to grant reconsideration, with the consequences that will follow from that. And so we say, in short, this is a powerful tool, one rarely used, and even more exceptionally, granted. The problem, and it's the problem that the Commission sees with the absence of the remedy, even in those cases of extremis, is that the individual dismissed on the grounds of their protected status doesn't even have a chance to make the application at all. And we say that's unsustainable. Turning briefly to the Equality Act, tab 8 of the authorities bundle. It's clear what the purpose of the Act is: to reform and harmonise equality law, restate the greater part of the enactments, and
I think we know this bit, Mr. Morrison.
sorry,
We know this bit.
I'm sure you do. Which is why I don't propose to spend too long on it. But just one point in terms of structure. Section 25 groups together the various guises of discrimination. So age discrimination is Section 13, Section 19, disability discrimination, 13, 15, 19, 21, etc. And then we have harassment and victimisation as standalone. We then go to Section 39, which is the substantive law prohibition on discrimination, discrimination having been defined in Section 25. And Parliament saw fit 39.2c and 39.4c to identify dismissal as a freestanding detriment rather than subjecting B to any other detriment, which would obviously encompass dismissal. Dismissal is not defined in the Equality Act, and so one presumes that the ERA definition applies. And then, of course, Section 119, which will be familiar to you as well, sets out remedies. And 1, 2, 3. If you give me 1, 2, 4 for the Employment Tribunal remedies. But the remedy is a tortious one, i.e., as good as money can do it, remedy the discrimination in circumstances where the purpose of the Equality Act at the time was to satisfy the obligations of the framework and recast directive, full, effective and dissuasive sanction. I'll make this point now. It clearly does not go against the grain of the legislation to do that which Parliament envisaged, namely to restore and remedy the injustice of a discriminatory dismissal by way of an order for interim relief. There may be other questions as to whether Section 3 has its limits here, but it does not go against the grain of the legislation to provide for a remedy of interim relief, because that is one means of restoring the statutory tortious wrong of a discriminatory dismissal. Now turning to the Convention and Article 14. Given the nature of this case, you will have doubtless familiarised yourself with the wording of Article 14 and the other substantive rights. If needed, the paragraph 175 of the Tribunal of the EAT judgment. The enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any grounds such as race, sex, race, colour, language, religion, political or other opinion, national or social origin, association with national minority, property, birth, or other status. There are a number of well-established principles which nonetheless bear some emphasis.
You say that. There are a number of principles where each successive case makes it more and more complicated.
Yes. I think we can agree with on this as a flaw.
Yes.
Article 14 is parasitic on the other convention rights.
It is.
But you don't need to establish a breach of those substantive rights. Clifton Stetch, where the state volunteers to go further than that which is required by the convention, it must do so in a non-discriminatory manner. Yes. And then thirdly, that the focus of the Article 14 consideration is to ensure that rights are not illusory, but are instead practical and effective, and therefore that there should not be deprivation of full enjoyment on suspect grounds. So the questions really are ambit of a substantive right, Article 14 status, analogous situation, justification, and those are the four that I will address in turn.
Yes.
Within the ambit is to be interpreted broadly.
Can I just catch up with this in your skeleton?
Yes.
You don't necessarily have to follow it.
No, that's fine.
Snail-like, but
because of I've got to do a bit more homework, as it were, than in the original submissions, because of course of the impact of the Secretary of State's intervention. But looking at the response to that intervention, we're really at paragraph 9, page 174. Onward. But given, as I say, given the breadth of the submissions of the Secretary of State, we're sort of starting on to a certain extent principles.
Yes.
Ambit, paragraph 9, I think, sets out the points that I raised. The EAT preferred Article 6, regarded Article 6 as a straightforward exercise. We agree. If there's any issue with that, we say we're also within the scope of Articles 8 and A1P1. Within the ambit, as I say, is to be interpreted broadly. Read C, tab 45, paragraphs 44 to 46 of Lord Justice Leggett's judgment.
Just a minute. Which paragraph of
44, my lord, page 993, if you're using page numbers of Read C or RC.
Yes.
Critically, the approach of the European Court treats each of the convention rights as surrounded by a penumbral area in which, although the right itself is not engaged, action by the state must not violate Article 14, Belgian linguistics. And on a similar note, tab 49, another decision of this court, Joint Council of Welfare of Immigrants and Secretary of State, paragraphs 83 to 84. as any. Adopting the observation of Baroness Hale and Brooklands application, it's fair to say the English courts have made rather heavy weather of the ambit point, particularly in connection with Article 8 because of its broadening, ill-defined scope. Lord Justice Higginbotham continued, in my respectful view, are courts of European authorities in an attempt to identify a set of rules for the definition of ambit of substantive rights in this context, which can be applied in the case before them, and indeed generally, whilst on other issues, as on other issues, the European Court has taken a relaxed and loose approach to the concept, which makes such close and comprehensive analysis difficult, if not impossible.
I'm so sorry, I'm behind you. Which tab and paragraph?
We're on tab 49, my lord. And it's paragraph 83, 1141.
Yes.
And then further on in Lord Justice Higginbotham's judgment, paragraphs 99 through to 100.
Right, thank you.
So ambit is broad, and even where there is essentially a penumbral area in relation to the substantive rights where there is Article 14 discrimination, the European Court and in turn domestic authority has been keen to get to the practical nub of the issue, bearing in mind the focus is on securing rights which are real and effective. I'll address the substantive rights in issue in turn, 6, 8 and A1P1.
Yes.
The point as regards Article 6 can be simply put. The substantive law is the statutory tort of discrimination as set out in section 39. That is the cause of action. The question of whether there should be interim relief is a procedural step to secure that substantive right. And in essence, we say that an interim relief order preserves the status quo, holds the ring to ensure that substantive justice on the substantive law right can be done. And so the reliance on Matthews and the other points that are raised in the Secretary of State submissions, we say are inapt to cover the present situation. Cause of action is section 39. It's not interim relief. And so we are not in the territory of substantive law, but within the ambit, which is of course a matter for the member states or the signatory states. But we are within the ambit of Article 6.
This point seems to me absolutely at the heart of the case. So I don't assume that we remember how Mr. Purchase puts it.
Yes.
I think you'd better look at how he puts it and take it head on, including any reference to cases.
What's said at paragraph paragraphs 24 through to 25, pages 59 and 60 of the core bundle. Reliance upon Matthews and Lord Walker, Article 6 is in principle concerned with procedural fairness and integrity of the state's judicial system, not with the substantive content of its national law. Similarly reference to Roche and Cahill. No arguable right to interim relief under domestic law. Accordingly, her complaint about the fact that the ET does not have power under the 2010 Act is not within the ambit of Article 6. Breaking that down a bit. We don't need to establish a breach of Article 6, merely that we are within its material scope. And indeed, as Lord Justice Leggett observed in C, essentially even within the penumbral area around the scope of Article 6. Secondly, the authorities on which Mr. Purchase relies are those where there is no substantive cause of action at all. In Matthews, there was no cause of action that could be brought against the MOD because of a prohibition on the face of the legislation. In Cahill, which is the question of whether a mother had the right to pursue the father of her children for non-payment of child maintenance, there was no substantive cause of action which enabled her to do that. Here, the substantive cause of action is Section 39, the prohibition on discrimination, which is to be applied by the Employment Tribunal. The question of whether or not there should be interim relief is much more in the territory of an immunity. It's in Ben Carbuche, which was accepted by EAT, Court of Appeal and Supreme Court as being an Article 6 issue.
Sorry, I don't follow that. An immunity?
The point I'm making, my lord, is that there are a broad category of instances where, on their face, it may look as though it's a substantive law issue rather than an Article 6 issue. But in reality, a number of them have been found to be within the scope and indeed a freestanding breach of Article 6. The State Immunity Act, the prohibition on pursuing a discrimination claim against an agency of a state, was held to be a breach of Article 6 in Ben Carbuche. And likewise, the cases that I refer to in my submission and reply set out at paragraph 10, page 175. Two cases in relation to discrimination which took place in Ireland, Northern Ireland, Tonelli and Devaney. The exclusion of a right to pursue discrimination on the ostensible grounds of national security, essentially a national security certificate precluding pursuit of discrimination claims, was held to be a breach of Article 6. And we say on proper analysis, interim relief is an order preserving the status quo so as to allow the application of the substantive law. The substantive cause of action is an Equality Act complaint, as set out in Section 39. At the very least, we are within the ambit of Article 6. And Mr. Justice Cavanagh was right to conclude that this was about access to the courts for the pursuit of a civil right which Parliament had already recognised, i.e. the right not to be subject to discrimination over which the Tribunal has jurisdiction.
So what it comes down to is, if you, Parliament, grant summary interim remedy to one type of litigant, whistleblower, you must grant it to every other type of litigant Otherwise, you are discriminating against all the others.
No, that's not what we say. What we say is that, as recognised in the Convention, in the ILO conventions, and on the face of the Equality Act, there are certain categories of reason for dismissal which are regarded as a particularly heinous wrong. The tort of discrimination. And on the spectrum, between an ordinary unfair dismissal claim, you were dismissed for gross misconduct, we could have handled the procedure better, we should have investigated more fully than we did, etc. On one hand, whistleblowing on the other, where does dismissal on the grounds of a protected characteristic sit? And we say it can't sensibly be thought to sit more closely to the ordinary unfair dismissal scenario.
But isn't
I'll develop this.
Isn't that's a value judgment?
Well, it's a value judgment which Parliament has made, and EU law has made, and the ILO conventions have made, that there is something on the, and recognised as such on the face of the convention itself, that there are certain suspect classes of reasons for ill treatment, and they include discrimination on the grounds of core statuses. Dismissal on the grounds of redundancy or capability or conduct is an altogether different creature than dismissal on the grounds of pregnancy, race, or religion. You don't need me to tell you that, my lord, because Parliament's done it itself. It did it from the age of the Sex Discrimination Act, from the RRA, and has done so continuously since, as has the European Court and the Convention itself, as have the ILO conventions, which I'll turn to in due course. Because what Article 14 recognises is that discrimination is not just about treating like cases alike, but different cases relevantly differently. Flemenos. Well, I'll come to that in due course. At the moment, I'm focusing upon substantive convention rights. The other reason we say that we're clearly within the scope of a substantive Article 6 right is because an express facet of Article 6 is that the civil rights are to be enforced within a reasonable time. So timeliness of enforcement is an express facet of Article 6. And it's been recognised by the Strasbourg authorities that there is a need for what they describe as special diligence and expedition in the context of workplace disputes. You have Ruotolo, tab 58. And it's paragraph 17. The court stresses that special diligence is necessary in employment disputes. This was in the context of delay. Now, the delay was of a different magnitude in Ruotolo. That's not the point. Because
yes, paragraph 14.
Quite
12 years.
But that was a case where it was a clear freestanding breach of Article 6.
Yeah.
We're only concerned for this purpose as to whether we're in the material scope within the ambit of Article 6.
It can't be enough that it's just about time, just about delay. I mean, that could be a matter of days or weeks, and it could be something a bit more than that.
Well, the point we make is this. where there are interlocutory measures which enable swift, expeditious vindication of the substantive law right in other scenarios, i.e. interim relief, the absence of such an expeditious remedy is within the material scope of Article 6.
Well, I think if the President of Employment Tribunals or anybody else were here, they would say special diligence is necessary in employment disputes, but the more court time we give to interim relief hearings, the greater the delays will be for every other sort of hearing. And so some people will gain swift resolution of their cases, but others will just have to wait their turn.
I recognise that issue, and you'll be unsurprised to say that I will come to it, because in my submission it's on the stronger end of the justification and disposal points that are made by the Secretary of State. The reason I have to take you through step by step is because the Secretary of State doesn't even accept that we're within the substantive scope of any, forgive me, within the scope of any substantive convention right. What I'm saying at this stage is that the timeliness of a remedy is axiomatically within the material scope, where there is an interlocutory emergency measure available, and it's not available in the present case. And that's particularly so when the courts have recognised in Strasbourg that there's a need for special diligence and what it described as an expeditious decision in the vocatory decision that's cited at paragraph 17 of Ruotolo. In the context of employment disputes. And indeed that's recognised as such by the fact that there is such a short limitation period, short primary limitation period for employment disputes. It has been suggested by the European authorities that the question of whether the question of the termination of employment is in itself a civil right, pursuant to Article 6. We see that from K&C in Hungary, tab 67. In which the court recognised that the termination of employment in the absence of reasons was in and of itself a breach of Article 6. There was a civil right to the continued pursuit of employment. And if we look at page 1729, the concurring opinion of the printed Albuquerque, there's a reference to the ILO Conventions 158 and 166, providing basic guarantees, valid reason for dismissal, the enunciation of non-valid reasons for dismissal. The non-valid reasons, union membership, union activity, acting as a workers' representative, and then at D, race, colour, sex, marital status, family responsibilities, pregnancy, religion, political opinion, etc. And then E, maternity leave. So what's built upon there is the international recognition that dismissal for reasons which coincide with the Equality Act protected characteristics is of a different category. And this goes back to the question that you asked me earlier, my lord, which is, are we comparing all unfair dismissal claims with whistleblowing claims? No. It's a question of recognising the unique status of a discriminatory dismissal, a dismissal on the grounds of a protected characteristic.
But that is quite a lot of dismissals. Of course, the employer always says it was gross misconduct or genuine redundancy or capability. The employee can say, no, it wasn't. You picked on me because I was a woman, I was ethnic minority, I was suffering from a disability, and so on. And these have to be resolved at trial. Of course, if it genuinely is a dismissal for gross misconduct, well, nothing wrong with that.
The overwhelming majority of dismissal claims before the tribunal are ordinary unfair dismissal claims in which an Equality Act contravention is not alleged. And we know that from the Secretary of State's own statistics.
Right. Okay.
So we say, even if one doesn't go so far as KMC in Hungary to suggest that the mere termination of employment engages Article 6, the access to a court in a timely manner, recognising the need for expedition and special diligence in employment disputes, is plainly within the scope of Article 6. And Mr. Justice Cavanagh was right to accept that there was a material, the case was within the material scope of Article 6. He was right also to draw upon Laing, in which the same point was made.
And that's Mr. Justice Cavanagh again. Can we look at that one?
The Laing decision?
Yes.
Yes. Tab 50. The issue there was the failure to extend qualified one-way cost shifting to discrimination complaints.
In the county?
In the county court. And the challenge was first put on the basis of a freestanding breach of Article 6, the Article 6 right of access to the court, and put on the alternative on the basis of Article 14. And at 165.1206, the facts will fall within the ambit of Article 6. No doubt answered in the alternative, in the affirmative, forgive me, since it relates to the access to the courts, not necessary for this purpose, as being a breach of Article 6.
Sorry, where are you? Where were you quoting from?
Paragraph 165 at the bottom of 1206. And then we see the alternative statuses that were put forward by Ms. Laing. Pure status of protected characteristic in issue, or the status of pursuing a discrimination claim in the civil courts. In a manner similar to here, the court. Justice Cavanagh there rejected the core status argument, but accepted that the status of being a litigant in a discrimination claim was an other status for the purposes of Article 14. So we say squarely within the scope of Article 6.
Though in the end he rejects the claim.
Yes. If not Article 6, we say Article 8. The point is made by Secretary of State that this court can't be satisfied as to whether Article 8 is engaged without findings of fact. The problem with that, of course, is it becomes entirely circular for the reasons that were recognised in Gillam and Vining, which is that the claimant can't pursue the application for interim relief until it's established that she has the jurisdiction to do so, at least as regards the discriminatory complaints. And so, as with Gillam and Vining, the court, as indeed the EAT did, must take the allegations at their reasonable highest in order to undertake the Article 14 analysis. It's well established that the workplace or the right to pursue employment can fall within the ambit of the right to pursue personal relationships, and that dismissal affects, impedes the pursuit of those personal relationships. We get that from Sidibras, but also Volkov, which you have at tab 68. This was termination of office of a judge. Paragraphs 165 to 6. Whilst it might be said that there are specific or special features in relation to the loss of office of a loss of judicial office, those in the court's analysis were secondary. We'd say there's at 166 to the wider observations that were made. 165, parties agreed there'd been an interference with the applicant's right to respect for private life. The court finds no reason to hold otherwise. It notes that private life encompasses the right for an individual to form and develop relationships with other human beings, including relationships of a professional or business nature. Article 6 of the Convention, Article 8 of the Convention protects a right to personal development and the right to establish and develop relationships with other human beings in the outside world. The notion of private life does not exclude in principle activities of a professional or business nature. It is, after all, in the course of their working lives that the majority of people have a significant opportunity of developing relationships with the outside world. Therefore, restrictions imposed on access to a profession have been found to affect private life. Dismissal from office has been found to interfere with the right to respect for private life. The court has also recognised that there are special considerations at play when the loss of employment is for reasons indelibly linked to personal, psychological or physical integrity of the person. Is they're part of the enjoyment of personal autonomy. Some illustrations of that. In Markin and Russia, the court held that the differential enjoyment of parental leave on the grounds of sex contravened Article 14 read together with Article 8. And in Stuthen, Germany and Obston, Germany, dismissal on the grounds of an extramarital relationship breached Article 8.
Sorry, what are you reading from?
I'm reading from my note, but Stuthen, Germany and Obston, Germany, you have it 65.
I'm not asking to be taken to these cases, just that I'm listening to what you're saying, but if you want me to
if I take you
write something down and look something up, then you need to go more slowly. Volkov appears to say that every employment dispute is an Article 8 case. Seems to be.
Within the material scope of Article 8,
yes.
I would say that is as far as it goes.
Doesn't have to be discrimination, it can be anything. Every employment dispute, large or small, seems to be.
Whether there's a breach or not is a different question altogether. As I say, the reason I have to go through this process is because the Secretary of State contends we're not within the ambit of any substantive convention right. Stufen, Germany, tab 65. Loss of employment on the grounds of an extramarital relationship was found to breach Article 8, let alone be within its ambit, and the reasons given for that, paragraph 55, whilst Article 8 is essentially aimed at protecting a person against arbitrary interference from state authorities, it does not merely require the state to abstain from such interferences. To this negative obligation, positive obligations inherent to the effective respect for private life may be added. So, because it touched upon a matter pertinent to or material to the enjoyment of a private life, there was a breach, and even more obviously an engagement with Article 8. Following tab, LB in Greece, we say is particularly informative. LB notified his employer that he had been diagnosed with HIV. And in response to that, the employer faced considerable pressure from colleagues to dismiss the individual because of ill-founded prejudice or concerns as to infection. That employment was short-lived, lasted for only 2 years. Looking at paragraph 11 of the court's judgment, page 1691, shortly after the dismissal, the applicant found another job in a private company. There's no obvious evidence of stigma in relation to what he had endured beyond the immediate employment. Nonetheless, the submissions of the Greek government were rejected, that there was no engagement or breach of Article 8, and the court concluded that there was a breach of Article 14 in the failure to provide special recognition for the circumstances of LB's dismissal, i.e. prejudice around a health condition. If I can take you to paragraph 67 of the court's assessment. The court reiterates that the notion of private life is a broad concept, not susceptible to exhaustive definition, covers the physical and moral integrity of the person and sometimes encompasses aspects of an individual's physical and social identity, including the right to establish and develop relationships with other human beings, the right to personal development, or the right to self-determination as such. The court continued at paragraph 72, clear that the applicant's dismissal resulted in stigmatisation of a person who, even if they were HIV positive, had not shown any symptoms of the disease, bound to have serious repercussions for his personality rights, respect owed to him, and ultimately his private life. The fact that the paragraph concludes, the fact that the applicant did find a new job after being dismissed does not suffice to erase the detrimental effect of his dismissal on his ability to lead a normal personal life. 76. As an employee of the company, the applicant could legitimately hope to continue working there as long as he did not commit an act capable of justifying his dismissal. However, he was dismissed shortly after it was revealed he tested positive for HIV. The court considers the applicant's situation should be compared to that of other employees in the company. Relevant to an assessment, it's clear that the applicant was treated less favourably than any of his colleagues, and that this was solely because he was HIV positive. And the other point that's made here by the court is because the reasons for dismissal were bound up with his disability, with his health condition, a narrow margin of appreciation is to be taken as to the discrimination. This was it adopted the submission of the applicant, paragraph 64, that factors such as undeniable prejudice, membership of a vulnerable group, victims of systematic discriminatory treatment and stigmatisation and social exclusion, were features which led to a narrower margin of appreciation. Final authority for this purpose, Boyraz in Turkey, tab 69, concerned the refusal to appoint Miss Boyraz on the grounds that she was a woman. And the court held, if I can take you to the second page of the head note.
Sorry, I'm still looking at LB and Greece. See, I can quite see why the applicant's dismissal on the grounds of saying that he was HIV positive was a violation of his Article 8 rights. They seem to go on to say that if you're one of a number of employees of a company and you're sacked and others aren't, that's differential treatment for because you're in an analogous situation to that of other employees of the company.
Yes.
So again, every dismissal is engages Article 8 plus Article 14.
Not quite. What the court says is that he, like others, should have had a legitimate expectation to continue their professional activity. And that came to an abrupt halt because of his condition. That was the Article 14 discrimination.
Oh, because he was dismissed.
Yes.
Yeah.
But he was not just he was dismissed generally. He was dismissed because of what the Equality Act would doubtless recognise, I think, in the Dean provisions recognises, is a disability.
Yes.
Boyraz in Turkey. Non-appointment to a security post on the grounds of sex. Second page of the court concludes that was a violation of Article 14 read together with Article 8. Take you to, as I say, the second page of the head note. The concept of private life extends to aspects relating to personal identity, and a person's sex is an inherent part of her identity, or his or her identity. Thus, a measure as drastic as dismissal on the sole grounds of sex has adverse effects on a person's identity, self-perception and self-respect, and as a result, on his or her private life. And if we go to paragraphs 38, just before we get there, paragraph 30, a common theme in these decisions is reference to wider international provisions. Here, the Convention on the Elimination of All Forms of Discrimination Against Women. I come back to the point I explored a moment ago in response to the question, my Lord. It is inapt to say that the individual dismissed on the grounds of sex is to be equated with the individual dismissed on ordinary grounds of capability or conduct or anything of that nature. time and again, both nationally and internationally, the unique feature of the protected characteristic infecting that decision making has been recognised. Paragraph 38 and 40 onwards, if we can pick up at paragraph 40, the court reiterates that Article 14 of the Convention protects individuals in similar situations from being treated differently without justification. No independent existence of Article 14 to become applicable suffices that the facts of the case fall within the ambit of another substantive protection provision. 42, the matter to be examined in this present case is not whether the applicant had a right to be recruited to the civil service. A few lines down, her submissions under this head concern the difference in treatment to which she had been subjected on the grounds of sex. And then over to 44. In the court's view, the concept of a private life extends to aspects relating to their person's identity, and the person's sex is an inherent part of his or her identity. Thus, a measure as drastic as dismissal on the sole ground of sex has adverse effects, etc. The passage from the head note. And then at 51, recognise that where the difference of treatment is based on sex, the margin of appreciation afforded to the state is narrow, and in such situations the principle of proportionality does not merely require that the measures chosen should in general be suited to the fulfilment of the aim pursued, but must also be shown that it was necessary in the circumstances. The court further reiterates that the advancement of gender equality is today a major goal in the member states of the Council of Europe, and very weighty reasons would have to be put forward before such a difference in treatment could be regarded as compatible with the Convention. And we'll come back to the concept of very weighty reasons in due course. But the point primarily I make at this stage is this. The categories of persons this appeal is focused upon are those whose dismissal is bound up with personal identity. Sex, race, age, pregnancy, sexual orientation, etc. In Boyraz, in Volkov, and in LB, it's clear that where that affects personal relationships, and frankly, even where somebody picks themselves up, dusts themselves down, and gets an alternative role swiftly, it's nonetheless within the material scope of Article 8 because it impedes and it interferes with the exercise of personal autonomy and amounts to an impingement on individual dignity. So we are clearly within the material scope of Article 8 when we're talking about those individuals who are dismissed for reasons which constitute a breach of the Equality Act. And then finally on substantive rights, Article 1, Protocol 1. Possession is defined broadly, includes, as I've set out in the submissions in response, paragraphs 13 and 14, matters such as employee benefits, company shares, wages, and causes of action, even if there's no judgment enforcing that cause of action, where there's a legitimate expectation in a cause of action or in the enjoyment of a property right, then Article 1, Protocol 1 is engaged. We say it's engaged in the present case in two ways. Firstly, wages and employee benefits. The claimant enjoyed a legitimate expectation for continued earnings, but for discriminatory or discriminatory repudiatory breach of contract. And secondly, a cause of action. The claimant is denied the opportunity to enjoy those rights expeditiously. Again, it's not a question of establishing breach, but material scope. And where the material scope is tainted by, or where the enjoyment of property rights is tainted by a protected characteristic, we see again informed by Strasbourg authority, anxious scrutiny is necessary. Tab 70, Đurđić in Croatia. Concerned an individual who underwent IVF, had a period of absence from work, and lost her employee-related insurance benefits. The insurance was cancelled. That was within the scope, so held the Strasbourg courts, of Article 1, Protocol 1. And because it was bound up with the claimant, the applicant's sex, there was a need for, again, weighty reasons to justify that. And we see in relation to justification the court's assessment at paragraph 62. For the purpose of Article 14, a difference in treatment is discriminatory if it has no objective and reasonable justification, if it does not pursue a legitimate aim, or if there's not a reasonable relationship of proportionality. And it continues, paragraph 64, that there's normally a wide margin of appreciation allowed to the state under the Convention when it comes to general measures of economic or social strategy. But at paragraph 65, the courts also stress that on many occasions the advancement of the equality of sexes is a major goal in the member states of the Council of Europe. So the context of transitional measures, very weighty reasons would have to be advanced before a difference in treatment on the grounds of sex could be treated as compatible with the Convention. Consequently, where a difference in treatment is based on sex, the margin of appreciation afforded to the state is narrow, and in such circumstances the principle of proportionality does not merely require that the measure chosen should in general be suited to the fulfilment of the aim pursued, but it must be shown that it was necessary in the circumstances. We say there's two further problems that claimants or victims of discriminatory dismissals face, which are pertinent not just to the scope of A1P1, but the justification exercise. Firstly, the delay in litigation leads to many people giving up, just withdrawing their claims. And if one looks at the statistical evidence from the Secretary of State, the majority of claims are not ACAS settled, but simply withdrawn. And there is evidence that the withdrawal is particularly acute amongst protected classes. Tab 72 is a report that the Citizen Advice Bureau prepared in relation to it is described as Tribunal trouble. It is worth.
When is this?
October 20.
Yes.
It is worth stating that, to the great credit of the tribunal system and the use of remote hearings, the picture is not as stark as it was in October 2020.
No.
The backlog is being cleared. But if we go to 1914 of the page numbers bottom corner there, this observation is made: disabled claimants are more likely to withdraw their tribunal claim, indicating that the tribunal process could pose increased barriers to disabled people. The surveyed claimants who decided to withdraw their case, over 1 in 3 had a limiting illness or disability, compared to 3 in 10 of all claimants. So the absence of swift remedy, we say, is leading to those of recognised vulnerable categories ultimately withdrawing their claim. The second feature is one which is recognised by the Supreme Court in unison and sadly has not changed since then, which is that many awards are not paid. Unison is at tab 52. And at paragraphs 35 to 37, tab 52, my lord. It's 35 to 37. This ET awards are enforceable in England and Wales by execution issued from a county court or otherwise, as if they're payable under a county court order. Many ET awards go unmet, even if enforcement proceedings are taken. A study carried out by the Department of Business, Innovation and Skills shortly before the introduction of fees found that only 53% of claimants who were successful before the ET were paid even part of the award prior to taking enforcement. Even after enforcement action, only 49% of claimants were paid in full, with a further 16% being paid in part and 35% receiving no money at all. This was noted to be a particular concern in the light of the forthcoming introduction of fees. And the report, which is annexed to the Secretary of State's, the statement in support of the Secretary of State's permission, the survey of employment tribunal applications from the 2018 survey, that's at tab 11, indicates that the enforcement issue remains a problem. And again, contrast that with the availability of interim relief, which enables a continuation of contract within weeks of dismissal. So we say we are plainly within the material scope of not one, not two, but three convention rights. The next question is status. The approach to an Article 14 status, toute autre situation, etc., is broad. The purchase relies upon Hooper. Things have moved on since then, not least by the decisions of the Supreme Court. Turning first to Clift, tab 23. Paragraph 60. Examples of wrong paragraph. Actually, we can just pick it up from RJM tab 29. Apologies. Which Lord Walker gave the definitive guidance on this issue from paragraph 5 onwards. Expression of personal characteristics. Personal characteristics, just at the bottom of the page there, are more like a series of concentric circles. The most personal circumstances are those which are largely innate, largely immutable, and closely connected with an individual's personality, gender, sexual orientation, pigmentation of skin, hair and eyes, congenital disabilities, nationality, language, religion and politics may be almost innate or may be acquired, but all are regarded as important to the development of an individual's personality. Just picking up on the substantive rights issue that I addressed you on a moment ago, he continues to say this: they reflect, it might be said, important values protected by Articles 8, 9 and 10 of the Convention. Now, in relation to Article 8, we say, if we're dealing with individuals dismissed on the grounds identified by the Equality Act, we are dealing with individuals who are dismissed for the enjoyment of their Article 8 rights. We're within the material scope, as Lord Walker at least tacitly acknowledged. The more peripheral or debatable, just by C, the more peripheral or debatable any suggested personal characteristic is, the less likely it is to come within the most sensitive area where discrimination is particularly difficult to justify. And then if we go to paragraphs 39 to 43, I'll just ask you to read 39 to 43, the question of status.
Beginning of paragraph 45, is that good law?
There's a question as to whether even that, who one is versus what one does, is where the law is as it stands. Tab 51 of Stott, paragraph 47, rather a long passage, so perhaps worth asking you to put on the list of conscious of time, but 47 to 47 on status of Lady Black's judgment.
Sorry, where's Stott?
Stott is tab 51, my lord.
Thanks.
Worth reading in full. If I can pick up from paragraph 56 of Stott. Summary of the 7 principles on the basis of the authorities which were reviewed leads Lady Black to conclude this. Possible grounds for discrimination under Article 14 were not unlimited, but a generous meaning ought to be given to other status. The Cadelson test of looking for personal characteristic by which persons or group of persons were distinguishable from each other was to be applied. Personal characteristics need not be innate, and the fact that the characteristic was a matter of personal choice did not rule it out as a possible other status. The support for the view that the personal characteristic could not be defined by the differential treatment of which the person complained, whilst there was a hint of analogous distant, and not really borne out by the substance of the decisions. There was some support for the idea that if the real reason for the differential treatment was what someone had done rather than who or what he was, that would not be a personal characteristic, but it was not universal. And the more personal the characteristic in question, the more closely connected with the individual's personality, and the more difficult it would be to justify discrimination. But the breadth of categories that are recognised include military rank, categories of planning permission, by way of a concession from the government in the Adiatu decision, being a LIMB worker. LIMB is defined by Section 230 of the Employment Rights Act, so the nature of a contract in which someone enters to work. In Leighton, being a litigant in county court proceedings. And such as the breadth of the status is recognised, that Lord Justice Henderson, paragraph tab 39, in the case of Stevenson, paragraphs 40 to 41,
$39, did you say?
tab 39, my lord, paragraphs 40 to 41. It should be recalled in this regard, citation from Clift, the general purposes of Article 14 is to ensure that where the state provides for the rights falling within the ambit of a convention which go beyond the minimum guarantee set out therein, those supplementary rights are applied fairly and consistently to all those within its jurisdiction unless a difference of treatment is objectively justified. And then Lord Justice Henderson continued, with apparent reference to this sentence, Lord Mance and Lord Hughes said that the European Court here expressed itself in terms which might literally read eliminate any consideration of status. That comment was made obiter. Nevertheless, it seems to me to provide a realistic recognition of the direction in which the Strasbourg Court's jurisprudence is moving, and to reinforce Lord Wilson's conclusion that if the alleged discrimination falls within the scope of a convention right, the question of status will normally be answered in the claimant's favour on the basis that he or she possesses either a personal or an identifiable characteristic assessed in light of all the circumstances of the case. In the majority of cases, it's probably now safe to say that the need to establish status as a separate requirement has diminished almost to vanishing point. Now, the way in which status was dealt with by the EAT here can be found at paragraph 185 of the judgment, page 279. 184, 278. He said this: the relevant status of the other status of being an individual who wishes to bring a claim of discrimination or victimisation arising from dismissal rather than the core status of gender, similar to the category of persons who have brought a claim for discrimination in the county court. On the other hand, I do not think the core status of gender is a relevant status for the purposes of these proceedings. The problem is that it's not specific to women. The problem about which the appellant claims not being able to claim interim relief is not specific to women, as it applies to anyone with any protected characteristic who wishes to bring a claim for discrimination or victimisation arising from dismissal. As I've said, every person has at least a few protected characteristics, and so is potentially a person who might wish to bring a claim for discrimination or victimisation relating to a dismissal. Reference to unisons, which I'll take you through in a moment. But then at paragraph 185, characterises my submission is that it may matter for the purpose of justification the concentric circles issue identified by Lord Walker. The EAT said this, however, in my judgment, the standard of scrutiny would essentially be the same whether the relevant status is gender or whether it consists of claimants in discrimination or victimisation cases. those not a core status, such claimants have an important status since they're seeking to enforce fundamental rights. We say both of those statuses are valid. Sex is obviously a valid status, but so too was the other status identified by the EAT. If this court concurs with the EAT that it makes no difference to the justification standard, then there's little need to go any further. But to the extent that it doesn't agree, the true status is in fact sex. Because what we're dealing with is individuals who are dismissed for reasons indelibly linked to a protected characteristic. And it is not a fair assessment of the comparison exercise to say, well, there are other individuals with other protected characteristics who are in the same boat. That becomes a zero-sum game. To compare the individual dismissed because they're a woman with the individual dismissed because they're disabled, it is wholly contrary to the direction of Article 14, which is that it's about real, practical and effective rights. And the comparison exercise, as identified by Lord Justice Maurice Kay and Burnett, to which I'll come to in a matter of moments. It's suggested that by Mr. Justice Cavanagh that individuals have at least a few protected characteristics, i.e. presumably some people may be white, male, middle-aged, etc. Well, that may well be the case. Everybody fits into one category or another. It's unlikely that they are dismissed for that reason. But if they are dismissed for that reason, if they are dismissed because of their age, their sex, their race, then they fall within the Article 14 core statuses for that reason. They're dismissed on their sex, it's just that the sex happens to be male. Dismissed on their race, it's just that their race happens to be white British. So, whichever way one cuts it, we are in the category of core status because individuals are dismissed for the reason identified, the discriminatory reason identified by Section 39 of the Equality Act.
Status, you put it, is discrimination claimant.
The status we put it is the individual who is dismissed because of their protected characteristic. And so in reality, the status is the protected characteristic itself. It's either a conscious decision to dismiss somebody because of that protected characteristic, or it's some measure of indirect discrimination, or Section 15 discrimination, which the Strasbourg authorities already recognise as part and parcel of Article 14. Article 14 is not just about treating like cases differently, but different cases relevantly differently. It's about affording special protection to those categories as well, which are bound up with core status. In fact, let's turn to that now. Burnett, tab 31. And it's the passage of Lord Justice Maurice Kay's judgment that starts at paragraph 10 through to paragraph 18.
So sorry, Mr. Milson. Which tab again, please?
It's tab 31, and it's paragraphs 10 through to 18. Melanie.
Thank you.
and Justice Morris Kay completed the picture by saying if there was any room for doubt, it was filled by reliance upon the UN Convention for the Rights of Persons with Disabilities, UNRCPD. What we say is this: on proper analysis of those who are dismissed on discriminatory grounds, as defined by the Equality Act, there are individuals who either are dismissed because the protected characteristic operates on the mind of the discriminator, or they're dismissed because of what might be regarded as the indirect discrimination type claims, discrimination arising in consequence of disability, failure to make reasonable adjustments, indirect discrimination. But those individuals, for the purposes of Article 14, as Burnett recognises, are to be treated relevantly differently. So whichever way one cuts it, the core status, that of the protected characteristic itself, is the true status in play. The other way of looking at it, which I explored with the EAT below, is the impact of unison. In unison, the Supreme Court held, because the Supreme Court unanimously concurred with Baroness Hale, that there was indirect discrimination as well as a breach of effectiveness and the common law rights of access to a court by way of the fees regime. That there was also indirect discrimination. And the analysis of the Supreme Court was that the Type B claims, which attracted higher fees, unfair dismissal and discrimination, more women pursued those claims, including unfair dismissal claims, than men. There was a 10% differential. And so therefore, the fees regime was indirectly discriminatory and there was no justification for it. The Supreme Court rejected...
Well, obviously, we all know the case itself, but you'd better take us to that.
Tab 52, my lord. And it's paragraph 125.
Okay, tab 52, paragraph
125. The particular disadvantage as identified there was that there was something of a 9% lag between women pursuing Type B claims and men pursuing Type B claims. That was sufficient for the purpose of particular
what was
disadvantage.
Type B was Equality
Type
Act?
B was Equality Act and unfair dismissal. And that's the important bit, for reasons that I'll come to in a moment. Nonetheless, that 9% differential couldn't be justified, and so therefore the indirect discrimination challenge was made out. The alternative way of putting the claim was at 132, paragraph 132, which is that charging higher fees for discrimination claims is indirectly discriminatory against women who bring the majority of such claims, protected characteristics who also bring them. And Baroness Hale said that there was a superficial attraction to that argument, and why it's superficial is dealt with in paragraph 133. Deterring discrimination claims, she continues at 132 for present purposes. Deterring discrimination claims is thus in itself discrimination against people, by definition people with protected characteristics who bring them. However, the problem in there is dealt with at 133, because the PCP was the higher fees for all Type B claims, and men pursuing Type B unfair dismissal claims were in the same boat. That's the reason why the superficially attractive route could not succeed in unison. The The same does not apply here. Because we say that the exclusion of Equality Act dismissals, bearing in mind what's said in Burnett about not comparing with the able-bodied, etc., don't compare with the able-bodied. This is a specific exclusion of Equality Act dismissals. And so therefore, this superficially attractive route...
It's not.
That we've got.
How do you say that? Parliament has legislated, first time in 1975, second time in 1998, to create special categories, each of which is a very small subset. The first is a very small subset, and the second a rather small subset of claimants as a whole. Everybody else is excluded. It's not an exclusion of Equality Act claimants, you might as well say it's an exclusion of Section 98 employment rights unfair dismissal claim.
We say Burnett properly read excludes that comparison exercise because when it is wrong to compare that which requires special circumstances with the ordinary state of affairs. But even if you're not with me on that one, the analysis from Baroness Hale in relation to Type B claims, which would include the ordinary unfair dismissal claims, still holds. Because the majority of those excluded are women. Excluded from the scope of interim relief. But we say Unison corroborates the argument, but the principal issue is, for the purposes of cause status, those who are dismissed for an Equality Act contravening reason share a cause status, and the cause status is the protected characteristic itself. Finally, for the A14 analysis, before we turn to justification, comparison. At tab 20, Carson, paragraph 3, Lord Nichols, page 434 says this. I prefer to keep the formulation of relevant issues as simple and non-technical as possible. Article 14 does not apply unless the alleged discrimination is in connection with the convention right and on the grounds stated in Article 14. The prerequisite is satisfied. The essential question for the court is whether the alleged discrimination, that is, the difference in treatment of which the complaint is made, can withstand scrutiny. Sometimes the answer to this question will be plain. There may be such an obvious relevant difference between the claimant and those with whom he seeks to compare himself that their situations cannot be regarded as analogous. Sometimes where the position is not so clear, a different approach is called for. That was adopted by Lady Black. For your note, I don't propose to turn to it. It's Stott, tab 51, paragraph 8. Perhaps also rather more pressing to turn to is Ale, Serbia, tab 24. And in particular, paragraphs 23 onwards. To 25. we say that the analogy to be drawn is between the individual dismissed because of their protected characteristic, in the sense envisaged by section 39, and the individual who is dismissed for whistleblowing.
Yes.
And I'll explain in a little more detail where that comparison takes you. As I say, we accept that the arrival of interim relief was originally in the context of trade union activity and membership. It has since moved far beyond that. It's worth spending a moment on the arrival of the PIDA provisions. The Public Interest Disclosure Act was introduced by way of a private member's bill. And there was no single anti-discrimination statute at that point in which it could sensibly sit. The Sex Discrimination Act, the Race Relations Act, etc., would have looked a little odd incorporated into those statutes. And so it was introduced instead, it was incorporated in 1998 into the Employment Rights Act. And we see its provisions at tab 4. Given the points that are made on the public interest, perhaps worth turning first to 43B. The gateway is a reasonable belief of the worker making the disclosure, both as to its, firstly as to its accuracy, secondly that it engages a relevant gateway, and finally that it's in the public interest. Of course, the public interest test was inserted in 2013, and so for the first 15 years-ish of interim relief being made available for whistleblowing complaints, it was not there. We know, in any event, that it's not the role of the court to determine objectively whether the disclosure is in the public interest, merely that it is supported by a reasonable belief to that effect. The reason I say this is because the public interest issue is identified as a differentiating feature by my learned friend. Chesterton, tab 41. Paragraphs 28 and 30. These two preliminary points from Lord Justice Underhill suffice. Second, and hardly moving much further from the obvious, element B of that exercise, i.e. the reasonable belief issue, requires the tribunal to recognise, as in the case of any other reasonableness review, that there may be more than one reasonable view as to whether a particular disclosure was in the public interest. And that is perhaps particularly so given that the question is of its nature so broad textured. Parties in their oral submissions refer both to the range of reasonable responses approach and the Wednesbury approach. Of course, we're in essentially the same territory. And then at paragraph 30, fourth, whilst the worker may have a genuine and reasonable belief that the disclosure is in the public interest, that does not have to be his predominant motive in making it. I'm inclined to think that the belief does not in fact have to form any part of the worker's motivation. The phrase "in the belief" is not the same as motivated by the belief, but it's hard to see the point of rise, etc. So it is not the role of the tribunal to determine objectively whether a disclosure is in the public interest. There are a range of views that may be appropriate, and given the broad and open textured nature of protected disclosures in cases that have been decided since 2013, they do not all sit within the high threshold of public interest that seems to be urged by the Secretary of State. Pausing there for a moment, the EAT considered a straight equivalence in comparing the statutory provisions themselves, 103A and Section 39 of the Equality Act. And section 103A was the right for automatic unfair dismissal. And it did that in the context of the equivalence argument. So its focus was upon the provisions rather than the people engaged. It's a straightforward analysis of the statutory regime affecting both rights. And what the EAT concluded, paragraph 93, page 92, page 241. The two sets of claims, section 39 Equality Act, section 103A Employment Rights Act, are comparable for the purpose of the equivalence principle. In both cases, they are claims that arise because the employer has treated the claimant less favourably in a particular way by dismissing them. In both cases, it is based on the contention that the reason for dismissal was an impermissible one. And whilst there were differences that were identified in the regime, time limits, etc., that comparison was sufficiently close to pass the total test, which was relevant for the purposes of equivalence. And the EAT was fortified in that view at paragraph 93 by the fact that discriminatory dismissal has a subsection to itself in the Equality Act, section 39 2C, as does dismissal by way of victimisation. It got there, in part, by looking at a suite of authorities, 97 to 100, which made clear that whistleblowing was an anti-discrimination statute. It's an anti-victimisation statute, as its long title made clear. And so in Woodward, paragraph 97, Woodward concerned the question of whether post-termination whistleblowing could be actionable. There's a case in the Court of Appeal at that point, Philippe, which made it clear that it couldn't be. In the intervening period, Rees Harper had reached the House of Lords. And so there was a question of whether Rees Harper, which allowed for post-employment victimisation in the Equality Act, could be read across, thereby circumventing Philippe.
Mr. Milsom, the clock is 20 minutes slow, so we're a bit past 1 o'clock. I sense that you're embarking on a new section of Mr. Justice Cavanagh's judgment.
Yes.
So shall we break off there?
Yes.
We'll come back at when that clock shows 1:45, but when my watch shows 2:05.
Thank you.
How far do you think you've got to go, Mr. Milsom? I know to some extent it depends how much I, in particular, ask you questions, but what's a reasonable estimate?
I'll hope another hour.
And Mr. McHugh and Mr. Purchase, we're quite happy that you should go in whichever order you've agreed, if you have agreed.
I'm grateful, Lord. Yes, we have. The intention is I will follow Mr. Milsom, and then anything will be picked.
Then Mr. McHugh can sweep up after you.
Take my mask off for this, can't I?
Right.
Excuse me.
Okay.
Yes.